Yo, mic check 1 2 1 2. Just checking out to make sure the vocals is working. Yo, what's going on? I appreciate everybody for tuning in. This is going to be a really short video because your boy got a lot to do. I didn't realize it, but I've taken on a lot to do. School, this 9 to 5. Now I somehow turned into a neighbor who complained about stuff into representing the whole block, trying to figure out a solution. It is what it is. All those are good things. But that being said, I'm tired, and for some reason, I always got a lot to do. So we're going to dive in. I'm Marcus. Here we do attorney reactions to current events and trending news. Hey, I've been doing this for 15 years and some change. I've been around the block. I'm old in this legal game. I'm a veteran. I'm not a crusty veteran yet, but I'm still a veteran. Shout out to the first comment of the day. I appreciate you. As always, Maddie, thank you for tuning in. And you definitely get a round of applause, a big salute. I'm very grateful for everybody who tuned in to check this out. Now, we're going to do one video. I know everybody going to complain. I'm going to put a timestamp on the video when I get done. But we're going to talk about one thing before we dive into our main story. I thought this was interesting because it's actually a story of attorneys doing bad things that could end up leading them into custody. Hey, as an attorney, I don't like people doing the wrong thing in general. As an attorney, I really don't like attorneys doing the wrong thing because when an attorney does something wrong and screw somebody over, most times it's them taking advantage because they have a superior amount of legal knowledge, not general knowledge, but legal knowledge, and they're using that. I had to see what this dog was doing, using that to their advantage. So let's check out this video real quick. Then we're going to jump into our main story of Tiffany Henyard, her Fifth Amendment plea, what it means, why it was actually probably smart, and can investigators use that to go down the road of obstruction of justice. We're going to get on that, but let's dive into this video first. Bad attorneys doing bad things. Let's go.
A victory for deed theft victims here in our borough. Thanks for being with us on News 12 Brooklyn. I'm Amanda Bossard. A disbarred attorney is now convicted of stealing deeds from nearly a dozen minority homeowners. News 12's Nadia Galindo spoke with one of those victims about the bittersweet moment.
I already don't like this story because this dude just targeting minorities. Like, come on, like this is extremely predatory. I'm glad this dude got caught. Got to take some intermittent pauses because of YouTube, but I hadn't even watched this video. Somebody sent it to me, but So far, absolutely terrible. Not a fan. Glad he got caught. Glad he eating some charges.
He stole our lives. We were no longer happy in our house. We were feeling like strangers in our own homes.
What was a shining example of an American dream became the center of 13 years of suffering for Clotilde Sawadogo, who goes by Wendy, and her husband Patrice. And now the man who caused their pain is being held accountable.
I can say I'm happy it's over, but I'm not happy that he's going back home.
Thursday, Sanford Solney was convicted of stealing 11 deeds from black and brown property owners. The Brooklyn District Attorney's Office saying the Millwood man carried out a fraudulent real estate scheme targeting homeowners in foreclosure. The DA's office says his law license was suspended in 2012. He was disbarred in 2023.
Okay, real quick. This dude has been disbarred and suspended for a long ass time. So when you're dealing with someone, I don't care what it is. If it's a realtor, a doctor, an attorney, hell, it could be an automotive mechanic. There are ways to go online and confirm people's credentials. There are ways to go online and see if they're in good standing.
It's incredibly important to verify.
Okay, Chat GPT. But there are ways to go online and actually confirm that people have the proper state credentials as well. So don't skip that step. That's important. I know you think like, oh man, I called this law firm and they put me on the phone with someone who's actually licensed. Nah, sometimes it's people out there it's firms out there who do some shady shit. It's mechanic, plumbing companies that will send people out who are just jack of all trades but don't have the proper credentials. So make sure you do your due diligence and check. Most times you can do a Google search and it'll point you in the right direction.
Wendy says Solney stole the deeds of this property in East Flatbush and another in East New York as they look to sell them off by rushing them through paperwork.
It was a trick, tricking him to sign over the deed.
The 68-year-old is now facing up to 7 years in prison when he's sentenced on September 17th. Meanwhile, Wendy is optimistic about the impacts his conviction will have.
Now I can put a garden.
The DA's office confirms a judge will be signing an order to nullify the 11 fraudulent deeds, giving Wendy hope they'll finally get their properties back. In East Flatbush, Nadia Galindo, News 12 Brooklyn.
All right, so real quick, I'm going to tell y'all exactly what happened right here. Most times, as someone has intimate knowledge with scammers, most times scammers tend to target people in their communities. I've seen pastors pump multi-level marketing schemes, those jobs where you get somebody underneath you, then you get paid. I've seen pastors pump those to their church members. It always happens, but normally scammers operate in the community that they're involved in. So I guarantee you that the person who finessed them probably targeted people who are the same color as them, probably from the same geographical region as them, probably who have the same beliefs and ideologies. You aren't going to send you can't say the guy who scammed them couldn't go to the goddamn country club in upstate New York in the Hamptons and scam Bob and Tom out of their funds because they automatically going to look at them sketch. So a lot of times scamming is often relegated to the community where the scammer fits in the best. If you got a hood scammer like Jay Morrison, he's going to be popping that hood stuff about real estate is just like the dope game. It's completely not like the dope game, but he's going to pop that because it sounds good to the audience that he's targeting. So keep your head on the swivel. The last thing I'm going to say on this video, which was a terrible video, is deed fraud is the worst. Because most fraud that you see, people fall victim to it because they're either gullible, uninformed, or greedy. All of those three, again, is not a bad thing, but deed fraud is a little bit different from like a Ponzi scheme or something where I convince you to get in some fugazi investment. Deed fraud is a little bit different because these people were actually aware of what's going on, but we covered on this channel a lot of deed fraud where the homeowners have no clue that the title, the deed to their home has been transferred over until it's actually too late. Yes, there are services out there that'll report to you a change on your deed, but think about what I said. A service that reports a change on your deed are reporting it after the change has already been done. I'm gonna tell y'all what I do. I just take cursory checks, with the appropriate offices within my state, just to make sure that my shit is on the up and up. Deed fraud is one of the very few types of fraud where the victim isn't greedy, they aren't unaware, they aren't dumb, they're just living their life, and somebody comes behind them and finesses a bogus deed and try to scam them out of their property. So it's actually one of the worst types of fraud because the victim doesn't do anything to contribute it. They were just essentially taken advantage of. She deserves jail time, and those who colluded with her on the super rampant. Hey, jail time. All right, let's go ahead and jump into this, okay? Let's go ahead and talk about pleading the fifth, okay? Fifth. That's what we call it, FIF. I immediately thought of the Dave Chappelle skit, but there are some nuances to pleading the Fifth Amendment, okay? One, when you plead, we're just as an overview before I go into my notes. Pleading the Fifth Amendment has a different impact if you're a criminal defendant, if you're a witness to a crime, or if you're in a civil procedure. So again, someone pleading the fifth has a different impact if it's a criminal trial. It has a different impact if it's a civil trial. If it's a criminal trial, pleading the fifth is different for the defendant than it would be for a witness. So there are a lot of nuances. Everybody just kind of know, oh, you can plead the fifth and you don't have to answer questions. But I just thought, you know what, this is a good opportunity to go through it and talk about, as an investigator, are you able to use the fact that someone pled the fifth and they refused to testify because they didn't want to incriminate themselves in the crime? Can you use that against them for obstruction of justice purposes? So let's go ahead and, okay, in a criminal trial, the defendant has an absolute right to plead the Fifth Amendment. So it's not anything that should be frowned upon. The Constitution allows for you to do it. You don't want to expose yourself to, I don't want to testify what happened to crime A when me testifying that could expose me to some shady shit I did in crime B, and crime B is way more severe than crime A. So the law allows you to plead the Fifth Amendment. It's an absolute protection for the defendant, and in a criminal case, the defendant, again, they have the absolute right not to testify. Now, in a criminal trial, this is important. If it's a criminal trial and as a defendant, I go up and plead the fifth, the jury, the judge cannot make any adverse inference. So what that means is if I go up and they ask me a question and I'm a defendant and I plead the fifth, I plead the fifth, I'm not doing anything, I'm not saying anything. The jury can't look at that and say, you know what? The fact that he didn't testify proves to me that he's guilty as hell. Now, even though the jury can't do that, the judge will probably give them instructions not to take the defendant's pleading of the Fifth Amendment in a negative light against them for purposes of this trial, or it doesn't have any implication of their guilt. I'm just going to be honest. I think normal, everyday people, this is my opinion. Y'all let me know. If you watching a trial and somebody said, I plead the Fifth Amendment, I think that you're inherently going to think that they're guilty as hell. I think that's what most people will think. Y'all let me know in the comments, if someone pleads the Fifth Amendment and refuses to testify, do you inherently think that they're guilty, or do you look at it as, hey, that doesn't impact their guilt or innocence, it was just their right to do it? I think most people think that if you plead the fifth, you did some shit that you wasn't supposed to do. Yeah, I changed my painting. I got my Ernie Barnes painting up there to look more professional. This was my motivating painting when I was in law school. I give y'all the background. Long story short, check out Ernie Barnes. He was a graduate of NCCU, North Carolina Central University. He played in the NFL. He actually did the painting for good times where all the people was dancing and everything. Ernie Barnes did that painting in the school. The law school actually commissioned him to go and do this painting, and this painting right here was one of the first things I saw when I spent many hours in the library. It was really motivating. I tried to give it to my son in college because I thought it would motivate him like it motivated me, and to no avail. Everybody motivated by different things. But yes, I did change that painting. Okay, so now that we know Fifth Amendment, we're talking about in a criminal trial, absolute right of defendant. The judge or the jury cannot make an adverse inference. A prosecutor or judge cannot comment on the defendant's decision to remain silent, and the jury cannot draw any adverse inference of guilt from the defendant's silence. This is to protect the presumptive of innocence. Now, if you're in a criminal trial, that applies for the defendant. For the witness in a criminal trial, so I seen Paul do something, and now I'm a witness on the stand, and they're trying to get me to tell what I saw Paul do. A witness in a criminal trial can plead the Fifth Amendment if their testimony could incriminate them in a separate criminal matter. However, unlike the defendant, a witness can be subpoenaed to testify, and if they are subpoenaed, they must appear. But they can assert the privilege on a question-by-question basis. A witness to a criminal trial has to assert the Fifth Amendment. Hey, I refuse to answer that question on a question-by-question basis. And they don't have a blanket assertion. If we look at the defendant has a blanket assertion. Now, it's interesting because I'm a defendant in a criminal trial. I can say I want to plead the Fifth, and no more questions can be asked. I don't say anything. But it is possible. Let's explain this first. Okay, let me back up. So, defendant can make a blanket assertion generally. I plead the Fifth, no more question asked. A witness to a criminal trial, if you plead the Fifth, you have to plead it on a question-by-question basis. So they can ask questions of you, and you have to plead the Fifth Amendment each question. The judge is the one who determines if the witness, in fact, has an appreciable risk of being exposed to criminal prosecution. So if I'm a defendant, I do a blanket assertion, I plead the Fifth, no questions asked. If I'm a witness in the trial, they want me to testify against what I saw Jacob do. They ask me a question, I plead the Fifth. They ask me a question, I plead it again. Every question they ask, I have to plead the Fifth. And the judge is the one who makes the determination if the Fifth Amendment assertion that a witness is giving is justified. Because if I'm a witness and I don't want any exposure, or I don't want to look like a snitch, I would just go up there and say, I plead the Fifth, I plead the Fifth, I plead the Fifth, I plead the Fifth. But the judge actually makes the determination on, wait. Yo, DFD, you pled the Fifth to question number 3. Question number 3 doesn't even expose you to the risk of some criminal sanction. It just asks you, they ask you, where were you on or about December 14th, 2025? Well, it could expose you, but generally it's a question. If a question doesn't expose you to a risk, the judge could potentially compel and lean on a witness to testify, or they can actually have a hearing where the witness would have to explain outside the presence of the jury, and they make a determination of, does this expose them to something or other. All right. Prosecutors often give witnesses immunity, removing any risk of salvation if they testify. Once a criminal, now this is interesting. Once a criminal defendant chooses to testify, generally, they waive their right to the Fifth Amendment as to the scope of their testimony. So let's think about this, okay? The defendant in a criminal trial, if I'm in a criminal trial, if Henyard's in a criminal trial, she can do a blanket assertion for the Fifth Amendment. Essentially what that means is she says it once, it's implicated. But how is this put into play in actual court? If I'm representing Tiffany Henyard, I know she's going to plead the Fifth Amendment. She don't want to get on stand and testify because it could expose her to a bunch of other crimes. She doesn't go on the stand and testify. Well, why wouldn't you send her on the stand to testify? Because generally, once a criminal defendant chooses to testify, they waive their Fifth Amendment right as to the scope of their testimony. Now, why would that make sense? Well, you said the defendant can make a blanket Fifth Amendment assertion, but if they go on the stand, once they go on the stand to testify, they waive the right. Well, again, that's generally, but the logic behind it is this. If I'm representing the client, Tiffany Henyard, if Tiffany Henyard goes on the stand, and when she goes on the stand, she says, I plead the fifth. Once she's on the stand, she's in the mode to testify. It would be unfair to allow a defendant, let's just think about this logically. What sense would it make if I'm charged with a crime? What sense would it make to allow me to go on the stand and pick and choose what questions I want to answer and what questions I don't? By doing that, it allows somebody to really manipulate the facts in their favor. And courts have determined that that doesn't make sense and it's not fair. And it doesn't make sense. If you're a defendant and you're going to plead the fifth and not testify, you don't take your ass up there on the stand and testify. You just sit right there. It's a done deal. The minute generally you go up there and sit on the stand, you are subject to being asked questions, and that's when everything gets out of control. So, recap, criminal Fifth Amendment, it's an absolute right that you have according to the Constitution. No one is supposed to infer guilt or innocence from a criminal defendant asserting their Fifth Amendment right. The judge and the jury cannot infer guilt based on someone asserting their Fifth Amendment right. The judge is actually going to give the jury instructions not to take the defendant's assertion of the Fifth Amendment right to self-incrimination as an assertion of guilt or an implication of guilt. If it's a criminal trial and it's a witness, the witness can assert the Fifth Amendment. The witness has to do it on a question-by-question basis. The defendant can do a blanket assertion, most likely done by not going on the stand in the first place, because most times, generally, once the defendant goes on the stand, they waive their right to assert that Fifth Amendment privilege. So a lot of times you see movies, somebody on the stand, and they like, I plead the fifth. That's not generally how it happened, because if it's the defendant, they just wouldn't go up there. So defendant can do a blanket assertion. Generally, that's done by the defendant not going to testify. If the defendant goes to testify, generally, they waive their right to assert the Fifth Amendment. And the reason behind it is the defendant shouldn't get to pick and choose which question they want to answer and which questions they don't. You either shut the hell up or you're going to answer it all. And I mean, I think that makes sense. If it's a witness in a criminal trial, a witness cannot make a blanket assertion of a Fifth Amendment argument. A witness has to assert the Fifth Amendment question by question. They ask question A, they assert it. They ask question B, they assert it. If the judge determines that the question a witness asked and asserted the Fifth Amendment right to doesn't have a risk of future criminal sanction, that witness could potentially be compelled to actually testify. So a witness, again, can't get up there and plead the fifth to 27 questions, because not every question is going to implicate them in something that could have criminal exposure. So the judge is the person who determines, is there a real risk of the defendant or the witness being exposed to criminal prosecution by answering this question? What's going on, Bumblebee? Everybody tapping in. All right, so that's criminal Fifth Amendment in general. Now we're going to pivot, because there is a Fifth Amendment right to self-incrimination in a civil trial. Now, for civil purposes, it's a limited capacity, okay? One of the key differences between a criminal and a civil trial, remember I said in a criminal trial, if my client, the defendant, asserts the Fifth Amendment, the judge instructs the jury that they can't make a negative inference about his guilt based on that assertion. In a civil trial, is the exact opposite. An adverse inference can be allowed. A major distinction is that in a civil trial, if a party invokes the Fifth Amendment and refuses to answer a question, the judge or jury may draw a negative inference from their silence. This means that they can assume that the information, had it been provided, would have been unfavorable to the party invoking the privilege. I'm a defendant in a civil trial. Let's say it was a hit and run. No, let's say I was involved in a car accident, but I was intoxicated out of my mind, and I don't want to answer certain questions because it's one thing to be in an accident. It's one thing to be in an accident while you was driving jacked up, right? Now, let's say I refused a breathalyzer. I did all of these things. What that scenario would essentially be is I'm going to stand, hey, Marcus, isn't it true that on or about December 14th, 2024, at 6 o'clock, you were leaving the bar over on 3rd and Missouri Avenue? I plead the fifth. In a criminal trial, me doing that, the inference can be made as to my guilt. If it's a civil trial for damages because of an accident I was involved in, the jury has the right to infer that if I would have answered that question, it would have ended up bad. It would have been held against me. It would have been terrible for my case. So an adverse inference is allowed for people who plead the fifth in a civil case. If you plead the fifth in a criminal case, the judge and the jury can't make a negative association about your refusal to answer that question being associated with your guilt. Okay. Also, in a civil trial, if you're a defendant in a civil trial, the privilege has to be asserted on a question-by-question basis rather than a blanket assertion, and the court will determine the fear of criminal prosecution if it's real, if it's appreciable. All right. Now, typically, in a civil context, refusal to testify, even if it's under the Fifth Amendment protection, is damaging in a civil context because it prevents a party from presenting their side or introducing evidence that could be crucial in their case. Let's go back to the car accident situation. Car accident, I was jacked up. I was gone out of my mind, but I refused a breathalyzer. I refused to do a sobriety test, all of these things. I acted sane, not belligerent, loud. I changed my clothes before I left the bar so I wasn't smelling like some Hennessy or some yak or some shit. Let's take this actual fact pattern right here. If it's a civil trial, if I'm a defendant or I'm representing a defendant and the defendant pleads the fifth, he essentially lost that case. He's going to be on the hook for whatever monetary damages there are. Because in a civil trial, it's only the plaintiff versus defendant. If the defendant is going to go on the stand and not say shit and testify and plead the fifth to everything, how do they present their case? How do they present their counter lawsuit? How do they present their defense to defend against the assertions of the plaintiff? They can't. So if you plead the fifth in a civil case, it's going to be negatively held against you. Now that we got that out of the way, we know the difference if it's a criminal case and you're the defendant, if it's a criminal case and you're a witness, if it's a civil case. That's how the Fifth Amendment works under those three scenarios. Now, this is the interesting question, okay? Everybody here is familiar with what obstruction of justice is. Obstruction of justice is impeding law enforcement's efforts to investigate a potential criminal act. Long story short, I don't know if that's the official definition, but that's generally what it is. Now, someone asked me in an email, they was like, hey, if they're asking you about FOIA, Freedom of Information Act, then just so we're all aware, it was a Freedom of Information request that went to, now I'm a little bit fuzzy about this. It either went to Tiffany Henyard as a mayor or the executive office of the mayor. Normally, those requests don't go to an individual. It goes to the office of that individual. But at some point, a FOIA request was made. There was a meeting that they had, and all of the trustees were there. And Tiffany Henyard apparently, I have no paper here because everything is like cleaned up. But Tiffany Henyard apparently held up a paper and purported that this paper was something that people didn't believe it was. I don't know if it was the situation where she said that this paper is proof of a surplus, or I don't know if it was the paper where she held up or was talking about how she had a letter or something from an independent auditor. it was something that everybody is calling cap on. I think it was a surplus, if I'm not mistaken. Y'all let me know in the comments. But it was something that everybody called cap on. A Freedom of Information Act was requested for that specific document, and they never replied to the Freedom of Information Act request. Lisa, what is going on? I appreciate you for tuning in, sis. Hey, again, good financial game. Check out Lisa J Stock. She knows what she's doing. Bitcoin zooming. You got any Bitcoin? I sold mine some time ago. Now I'm like, but it'll go back down and ride back up. Let's see. That the trustees canceled the credit card. Okay, that's what it was. So Tiffany Henyard, thank you. I appreciate that, Charity. So Tiffany Henyard has this document that she purports to be something. No one believes it. She always was famous for like, I got this proof right here. That she put it in her jacket and nobody ever sees it. But a FOIA request was done. It was no response. Now, I don't know at the state level, but generally for a federal FOIA request, 20 days to reply. 20 days to reply, 30 if it's a complex or exceptional circumstances. But there was never any reply. She gets held into court. They bring her into court day one. She comes in on Zoom. The judge is like, yo, we need you here to testify. The next day she comes in. And when they ask her about what is going on with this FOIA request, why didn't you reply? She pled the fifth. The fact that she pled the fifth, she was of the belief that her answering that question would have subjected her to some criminal exposure in some capacity. The question I got was, could her assertion of the Fifth Amendment when being asked about her failure to produce FOIA records, could that be used to determine that she obstructed justice, impeded an investigation in some capacity? Now, the real answer is no. And why is the real answer no? Is because of what we talked about. The Constitution said that, hey, there's not supposed to be an inference of guilt associated with the amendment being asserted. So the general answer is no. But there could be some investigatory gamesmanship. Now, let me tell you what will happen. I'm an investigator. I'm investigating Tiffany Henyard. A FOIA request was done for records related to the use of credit cards, or the cancellation of credit cards. She goes up and she pleads the Fifth Amendment. She's like, you know what? I plead the Fifth. I'm not going to answer. Now, what would be interesting if I were an investigator, what I would do is, one, issue a subpoena for those same records, or two, actually call Tiffany Henyard in to testify under oath about those records. Now, that's a little bit different from obstructing justice, but it's a good way that investigators could take her pleading the Fifth for not producing those FOIA records and flip that off into potential criminal exposure. She didn't produce these records. She pled the Fifth. If I'm an investigator, I find out what were the records that were actually being requested. And one, I issue a subpoena for those records, because if you fail to comply with the subpoena, there's court exposure there. But the easiest way to do it is to actually, hey, speaking of subpoenas, let's go ahead and send one to you. So you have to come down and testify about this particular record. Now you got her under oath on the record, testifying about what this document that she had was, how it was created. Did she bring the document with her? And you can't necessarily get her for obstruction of justice, but there's a very, very good likelihood that the truth is not going to be told. Telling a lie under oath, bad, no-go. Lying to federal investigators, felony, no-go. That's how investigators could kind of manipulate her pleading the Fifth to a FOIA request to something that could get some criminal exposure. Because think about it. What do you think do you think that if they do a subpoena for her to come testify and they ask her, hey, on this date during a hearing, you told the trustees that, let's say there was a surplus and you held up this document purporting to show evidence. What was that document? You think she's going to go up there and say, no, well, actually that document didn't say anything about a surplus. It was actually a menu from the local carry out down the street because they had a bomb low menu. Hell no. She's not going to go up there. I would be shocked. She might, but that would be stupid. But I don't think she's going to go up there. That would probably be the best thing to do, to go up there and tell the truth that the document could potentially have been bogus. But do you think she's going to go up there and tell that? I don't know. I don't think she would go up there and say it was bogus. I would be shocked. Honestly, I would think most people in that situation would go up there, say that the document was what they said it was, whether that's false or not, even though that's cap probably. They would say, yeah, I actually had a document that showed we had a surplus. Where's the document? I don't know. I lost it. What was the document? I can't recall. That's probably where they'll go with it. But there is a way for investigators to spin off that failure to respond to a FOIA request, that Fifth Amendment assertion, protecting her from self-incrimination, into some type of criminal charges. It likely wouldn't be obstruction. It would be bringing her down, having her testify under oath, and seeing if you can get her to tell a falsity under oath and a falsity to an investigator. Those would be two separate criminal charges. Because she didn't have the records and she's still finding dollars a bit. Yeah, I agree. Unfortunately, I don't know if there may not be attorney fees associated with this, because I think at this level FOIA requests are done just like Joe Citizen, local media issuing a FOIA request to the government. There's not a lot of attorneys and litigation costs, so I don't think there'll be a lot of exposure here from litigation costs. But in her role as the mayor, if in fact she did do something shady on the FOIA side, that cost would be something that the people would have to pay. It wouldn't be her in her personal capacity. Oh, it's sounding a little crazy. Hold on, let me see something. See, my bad. Let me see. How is it now? It sound different now, better now, worse now? Let me know. I appreciate you dropping that. If y'all had a difficult time or something, let me know. I got trying to tweak some things, but that's essentially how this will play out. It can't be held against her. It was probably the smartest move that she can make. Investigators could spin it off into something if they're a little bit savvy and they bring her in to testify under oath about what that document was, the content, the context, where she got it from. Then they may be able to jam her up for providing false information under oath or an alternative line to federal investigators. Let's see. I know I did see or heard that she moved. Hey, I'm just saying. I'm not saying she's a scammer, but if I was a scammer, Atlanta probably would be the city I'm moving to. Like, Atlanta is like a finesse capital. It ain't the finesse capital, but is it? It might be. I don't know. A lot of scams happen in Atlanta. I'll just say that. I'm not going to say they're the finesse capital. Shout out to Atlanta. Hey, I'm just saying that I've seen a lot of stories. Finesses happen all over, but I've seen a lot of finesse stories come out of Atlanta. But, I mean, if you want to go rebrand yourself and rebuild yourself, what better place to go to than Atlanta? I'm still waiting to see if the reality show comes into fruition. I mean, honestly, I thought her YouTube channel would be kind of jumping by now. I went over and checked it out, but it wasn't rocking with anything. But yo, y'all let me know what y'all think about Tiffany Henyard and her assertion of the Fifth Amendment. Generally, and this is the question, if someone pleads the Fifth Amendment, I'm not talking about legally what's the right answer, we already went through that, but do you think if someone pleads the Fifth Amendment, do you take that as an indication of their guilt, or do you just think, well, they had a right to plead it, and I'm not going to hold it against them? I think most people think that if you plead the Fifth Amendment, you probably did some shit that you wasn't supposed to do. That's my thought, but y'all let me know in the comments. Hey, as always, I appreciate y'all for tuning in. And I apologize if the sound was a little janky. I don't know. I was doing something different with this microphone. Yo, y'all be safe, be blessed. I'm going to be back on Wednesday. Y'all let me know in the comments. I got two stories we can cover. We can go through the indictment of a pastor who was on the finesse side of the game, or we can go through an indictment of a DC attorney who was on the finesse side of the game. I think it may be too long to cover both of them, but y'all let me know which one y'all prefer to hear. I put a poll question up I put a poll question up on this video on the channel. Y'all let me know what y'all want to hear. Y'all take care. Be blessed. Be safe. Peace.